the prosecutor very astutely and in effect is attempting to introduce this picture to innervate a raw nerve in this jury. Clearly, the picture does nothing but invoke a visceral effect on anyone who watches it. Mr. Charamonte is correct. One of the jurors, whose number shall remain nameless now, couldn't even face the photo, couldn't even face it. An obvious sign that it's clearly not just inflammatory and prejudicial, because all of the state's evidence is prejudicial to the defendants. The question is, does it rise to the level where its probative value substantially outweighs its prejudicial value? There's nothing probative about the horrific picture in which the victim is laid. He's on the sidewalk, on his back, in a massive amount of blood that has spewed forth from his head. This is a homicide. No one's disputing that he was murdered by somebody not here today. The jury saw the photo. The medical examiner testified as to the cause of death and the manner of death. There is no probative value. There is no connection between the jury having that picture and them leading to a more reasonable inference than they could already draw. Because that's what the purpose of this picture should be for the prosecutor, if it were a valid purpose. It's a wily attempt to admit something into evidence that shouldn't be there. That bit of evidence does not bring the jury closer to, one, establishing a fact, establishing a truth, or drawing a reasonable inference. Everything that they would glean and know and learn from that picture is already in this case. Already.
Mr. Breite, sorry, what I was planning to do was I was going to ask all of you whether you are consenting or not. Then, because this is state's evidence, they're moving in, I was going to ask Mr. Morales to go first and tell me what is the reason that he wants to know. Unless you prefer to go and make your argument, because the proper procedure that I was going to ask was, if there is no objection, then I would have made a ruling on it. Because there is objection, I just want to see, I don't want you or any defense counsel to be in a position to anticipate what the state's argument will be. I know you're all, experienced attorneys. If you prefer, you can move on with your argument. If not, I want to hear from Mr. Equal. Then I want to ask Mr. Morales as to why and the grounds on which he's seeking to have this admitted.
Respectfully, Your Honor, I think that to the extent that this is, and I think there is no disagreement by counsel that this is relevant evidence in the case, and that the state has moved to admit it, I think that the objections need to be heard before the state can respond to those objections. So I would respectfully ask.
You have no objection to?
No,
they're going first.
I don't mind continuing.
Okay.
I mean, I'm not the smartest guy in the room, but I can anticipate what the prosecutor is going to say. The probative value substantially outweighs its prejudicial value, and so forth. So rather than having me get up twice and speak, which nobody wants to hear, I'll just briefly continue and curtail my argument. There is absolutely nothing to be learned, gained, in terms of learning facts or the truth from that picture being introduced. It's clearly inflammatory beyond what is reasonable. If it, however, offered something to a truth, to an assertion, a reasonable inference that the jury could draw, which they could not already draw, or even, I'll go so far as to give the prosecutor the benefit of this argument, if that picture could corroborate something that's in the case already. I'll go so far as to say corroborate in the case already. If that picture could do that without its clearly prejudicial status, I would not object. The prosecutor has no legitimate purpose to introduce a photo that's already been shown and inflame the jury. Photos akin to that showing the wound, the shot in the head to the victim. It's not as if this jury won't be able to see the autopsy photos. No, they will have those. So given that, there is no legitimate purpose to introduce a document that is not only prejudicial, but more importantly, does not move this jury closer to establishing a reasonable inference, which they could not draw but for that document, or bring them closer to the truth. Thank you.